Welcome back, everyone. Ready for another deep dive?
Always ready to dig in.
Fantastic. We're going to untangle the world of obligations and contracts in Philippine law.
This is foundational stuff. It's crucial whether you're doing business there or just living life in the Philippines.
You can't really navigate the legal landscape without a good grasp of how contracts work.
Absolutely. Every agreement, every deal relies on these principles.
And to show you just how tricky things can get, we've got a real head-scratcher of a case. Sisuan versus Regala. It's mentioned in our source material, and it's fascinating.
Oh, this one. I remember this case.
A businessman, Sisuan, got sued because his old job contract supposedly said he couldn't start a similar business after leaving.
Yes, those non-compete clauses can be tricky.
The big question is, was that restriction even legal under Philippine law?
We'll get to that, but first, let's rewind a bit.
Good point. Let's define our terms. What exactly is a contract under Philippine law? It can't just be any casual promise, right?
Right. There's a distinction. Article 1305 of their civil code is pretty clear. It says a contract is a meeting of the minds, where one person agrees to do something, give something, or provide a service to someone else.
So two people agree they've got that meeting of the minds, boom, instant contract.
Not quite. There's this crucial element called patrimonial obligations.
Patrimonial obligations. That sounds fancy.
It means that the core of the agreement has to involve something with financial or economic value.
Okay, so it's not just about agreeing to meet for coffee. It has to involve something with real financial weight to be a legal contract.
Exactly. Think of it as a line between casual promises and agreements that carry real economic consequences.
Makes sense. So once we know it's a real deal, a true contract under Philippine law, what are the guiding principles? How do these contracts actually work?
Philippine contract law is built on four main pillars.
4 pillars. Lay them on me.
Mutuality, autonomy, relativity, and the concept of breach.
Okay, those are some big words. Let's break them down. Starting with mutuality, what does that mean in practice?
Mutuality means both sides are equally bound by the contract. No one-sided deals. It can't be a situation where one person calls all the shots.
So no sneaky power dynamics.
Exactly. Article 1308 of the Civil Code reinforces this. It says you can't leave the validity or the fulfillment of the contract to the whims of just one person.
Got it. No dictators in contracts. But what about autonomy? Does that mean you can agree to anything under the sun as long as both parties are willing?
Autonomy does give parties a lot of freedom. They can generally agree on whatever terms they want.
So freedom of contract.
To a point. There are limits. It's not a free-for-all.
Limits. Like what?
You can't agree to something illegal, something that goes against basic morality or good customs, or something that threatens public order.
So no contracts for, like, robbing a bank or something?
Definitely not. That would violate public order, harming society as a whole. And these limits on autonomy aren't just implied, they're right there in the law.
Where do we find those?
Article 1306 of the Civil Code addresses this directly. And even the Philippine Constitution echoes these limitations.
So the contract can't overrule the Constitution. Checks and balances. Okay, what about relativity? That one sounds kind of complicated.
It's actually pretty straightforward. Relativity means a contract only affects the people who signed it, the parties involved. It doesn't impact outsiders.
So no random strangers can suddenly jump in and say, hey, I want a piece of that deal.
Exactly. It creates a sort of legal bubble around the people who made the agreement. Article 1311 of the Civil Code lays this out clearly.
It's all about keeping things contained to the people who actually agreed to be bound, right?
Right. And there's this fancy legal principle that backs this up. Res inter alios acta alias negem nocet prodest.
Whoa, that's a mouthful. Care to translate?
Basically, it means what happens between two people shouldn't affect a third.
Simple enough. Can you give an example of how this plays out in real life?
Sure. Let's say you and I have a contract for me to, I don't know, bake you a cake.
Sounds delicious.
Your neighbor can't just walk over and say, hey, bake me one too, just because they overheard our agreement.
Right. They weren't part of the cake contract. Yeah. Their sweet tooth doesn't give them legal standing. Okay, lastly, there's breach. That one sounds pretty self-explanatory, but I'm sure there's more to it than meets the eye.
You're right, it sounds simple enough. A breach is when someone doesn't hold up their end of the bargain.
So they promise to do something and then do.
Exactly. But there's an important caveat. For it to be a legal breach, there can't be a legal justification for that failure.
So you can't just say, oh, I couldn't do it and get away scot-free.
Nope. You need to show the court that there was a legit reason why you couldn't fulfill your obligations.
Like a force majeure or something.
Exactly. An act of God, something completely unforeseen that made it impossible to fulfill the contract. And there's a case that perfectly illustrates this, Ms. Edgar and Dinah Omengan versus Philippine National Bank.
Ooh, a real-world example.
It shows how a court examines whether a breach was justified or not.
Okay, all this talk of restrictions and breaches makes me think about that Saswan versus Regala case again. Can a contract actually stop someone from working in a certain business? That seems pretty limiting.
It's a complex area, and Philippine law has actually changed its stance on this over time.
Really? So what was the old rule?
Early on, any contract that tried to stop someone from doing business, like anywhere or at any time, was pretty much automatically thrown out. Too restrictive.
So it was a hard no on those types of clauses.
Pretty much. But things started to shift.
How so? Did they just do a complete 180 and start allowing any business restriction?
Not quite. They started allowing restrictions if they were tied to a specific place and a specific amount of time. So you could agree not to open a competing business, let's say, within a certain radius and for a certain number of years.
So like no competing pizza places within 5 miles for 5 years after leaving the old job, something like that.
Exactly. Limited in scope. But even that rule didn't stay put. It evolved even further, and now the focus is on reasonableness.
Reasonableness. What does that mean in the world of contracts? How do you measure that?
The question becomes, is this restriction truly needed to protect the legitimate interest of the people involved in the contract?
So not just arbitrary limitations, but restrictions with a real purpose.
Exactly. And the Saswan versus Regala case is a prime example of how the court applies this reasonableness test.
Okay, now I'm really curious to hear how that one turned out.
We'll get to that. But first, there's another interesting twist we need to explore. Stipulations por atruy.
Stipulations por atruy. What in the world is that?
It's a fancy way of asking, can a contract benefit someone who's not one of the people who signed it?
Wait, seriously? Like a secret bonus for someone lurking in the background?
In a way, yes. Article 1311 brings these stipulations por atruy into the picture. It's like a built-in benefit for a third party.
Do you have an example? This is blowing my mind a little.
Sure. There's a classic case, Kokia versus Fieldman's Insurance Co. In that case, the parents of a driver who died in an accident actually received insurance benefits.
Wow, so even though they weren't on the insurance policy itself.
They benefited because the policy had a clause designed to benefit the driver, and that benefit carried over to the driver's heirs.
That's incredible. But I'm guessing there are rules around this. It can't just be any random person reaping the rewards of a contract they weren't part of.
You're absolutely right. For a third party to benefit, several things have to be true.
Hit me with the criteria.
First off, the contract has to explicitly state that this third party gets this benefit. No ambiguity.
So crystal clear intention. What else?
This benefit can't be the whole point of the contract. It has to be a specific part of a larger agreement.
Okay, a specific perk. Makes sense.
And importantly, the people who made the original contract have to have intentionally put that clause in there to benefit this third party. It can't be an accident.
So a deliberate bonus. Got it.
Also, that third party has to actually accept this benefit before anyone can take it away. Otherwise, it's like a gift they never claim.
Right, like an uncashed check.
Exactly. And one last crucial detail. Neither of the original people who made the contract can be acting as the third party's legal representative when they make the deal.
Okay, so no funny business, no conflicts of interest. This third party needs to be genuinely separate.
Right. It's all about preventing manipulation or hidden agendas.
So these stipulations por atruy add a whole other layer of complexity.
They do. But let's not forget about our businessman, Mr. C. Swan, and his legal battle.
Oh, yeah. We left him hanging. Was that restriction on his business activities even legal? What did the court decide?
Well, the court actually sided with Swan. They said that restriction was valid.
Wow, really? So even though it limited his options?
The court said it was a reasonable restriction. Remember, this guy had access to all sorts of sensitive company info, client relationships, trade secrets, that kind of thing.
So preventing him from immediately using that knowledge against his old employer.
Exactly. It all boiled down to that reasonableness factor we talked about. They decided that stopping him from working in a similar field for 5 years was a fair way to protect the company.
It's like a balancing act, right? Protecting freedom of contract, but also preventing unfair competition.
Precisely. And it highlights how the specific facts of each case really matter.
Okay, so sometimes those restrictions are legal. Interesting. Now, our source material also mentions situations where a contract can create rights for people who aren't even part of the agreement.
Ah, yes. That's where things get a bit more
It
complex.
seems counterintuitive. If you're not in the contract, how can it affect you?
Well, this is where real rights come in. These are different from personal rights.
Real rights versus personal rights. What's the difference?
Personal rights are only enforceable against specific people. Real rights, on the other hand, are attached to something tangible, like a house or a piece of land.
Okay, so it's like the right is tied to the thing itself, not just the people involved.
Exactly. And those rights are enforceable against anyone who interacts with that property, whether they knew about the original contract or not.
So it's like a legal force field around that property.
You could say that. Let's say you buy a house, and it turns out there's a mortgage on it from the previous owner. You weren't part of that mortgage agreement.
But I'd still be stuck with it.
You'd be bound by its terms because it's a real right attached to the house itself.
Yikes. Talk about hidden surprises. Is there anything in Philippine law that deals with these real rights specifically?
Article 1312 of the Civil Code tackles this head-on. It basically says that if a contract creates a real right, whoever ends up possessing that thing, like the buyer of a mortgaged property, is bound by those rights.
So even if they weren't part of the original deal?
They inherit the obligations that come with that property?
Makes sense. But what about laws specifically related to mortgages or land ownership?
Of course. This whole area is also governed by things like the mortgage law and land registration laws. It's a complex system.
A lot of moving parts. But it's good to know there are safeguards in place. What if someone tries to get sneaky and create a secret agreement that contradicts the original contract, trying to bypass those real rights?
Well, Article 1313 is designed to prevent exactly that kind of mischief. It protects creditors.
Creditors, so the people who are owed money.
Right. It makes sure that people can't create shady side deals to avoid paying their debts or to get around existing obligations tied to a property. The law sees through those attempts to cheat the system.
It's like a legal shield for creditors. That's reassuring. But what about someone who's not part of the contract but encourages one of the parties to break it? Do they face any consequences?
That's a great question, and Article 1314 has the answer. It says that if a third party pushes someone to violate their contract, they can be held liable for the damages caused to the other contracting party.
So it's like a legal deterrent against meddling in other people's agreements.
Exactly. It emphasizes the importance of respecting contracts, even if you're not directly involved.
It's not just about the people in the contract. It's about the integrity of agreements in general. Now, let's go back to the very beginning, to the moment a contract is born. We know there needs to be that meeting of the minds, but how does that meeting actually happen in a legal sense?
Article 1315 sums it up beautifully. Contracts are perfected by mere consent.
Perfected by mere consent sounds almost poetic. What does that mean, practically?
It means that once both sides agree, the contract becomes binding. And from that moment on, they're not just bound by the specific words written down, but also by anything that naturally follows from the agreement.
Okay, so it's about acting in good faith, understanding the spirit of the agreement, not just the letter of the law.
Exactly. But it's all within the bounds of the law, of course, and existing customs. No one can just make up their own rules.
Right, the contract exists within a larger legal framework. But how do we know when this perfection by mere consent happens? When does a contract become official?
That's where we get into the dance of offer and acceptance.
Ooh, a dance. Sounds intriguing.
One party proposes a deal, laying out the terms, that's the offer, and the other party has to accept those terms, that's the acceptance.
Simple enough.
And that acceptance can be a clear, yes, I agree, or it can be implied by actions that clearly show agreement.
So you don't always need a formal declaration. Actions can speak louder than words. But what if the offer and acceptance happen over a distance, like through emails or letters? Does that change anything?
Good question. Article 1319 clarifies that an acceptance sent by mail or telegram only binds the offerer from the moment they become aware of it.
So it's not when you hit send on that email.
It's when the other person actually receives and understands your acceptance. Only then is the contract truly perfected.
That's crucial in our digital age, where communication can be so instantaneous. It clears up any confusion about when a contract actually takes effect. Speaking of which, what about those flashy ads we see everywhere? Those tempting offers, are they considered binding contracts that you can just accept right away?
Article 1325 tackles that head-on. It says those ads, unless they explicitly state otherwise, are not firm offers. They're more like invitations to make an offer.
So those limited time sale ads aren't forcing the seller to sell to every person who walks in.
Exactly. They're inviting potential buyers to come forward and propose a deal, and the seller still has the right to accept or reject those offers.
So those ads are more like the opening act, the start of a negotiation.
Precisely. They're not the final word.
Okay, that makes sense. It gives businesses flexibility while still enticing customers. Now, we talked about how minors and those with mental impairments might not be able to legally consent. Are there any other situations where someone might not be considered capable of agreeing to a contract?
Definitely. Article 1327 lays out a few key categories. First, we have unemancipated minors.
Unemancipated minors. What does that mean exactly?
Basically, it means someone who hasn't reached the legal age of adulthood and hasn't been declared legally independent. The law understands that they might not have the maturity to fully understand the implications of a contract.
So it's about protecting young people from agreements they might regret later.
Exactly. Another category is people with mental impairments.
Right. We talked about that earlier.
Article 1327 specifically mentions individuals who are insane or demented.
So if their mental state prevents them from truly understanding and consenting,
Then the contract isn't legally binding.
it's about preventing exploitation, making sure consent is genuine. Are there other groups that fall under this umbrella?
Article 1327 also includes deaf mutes who are unable to write. This highlights the importance of communication and understanding. If someone can't effectively communicate their agreement, then it's not a valid contract.
So the law recognizes that communication is key. It's not just about signing on the dotted line. It's about truly understanding what you're agreeing to. But what about situations where someone's impairment is temporary, like if they're drunk or hypnotized? Does that impact their ability to consent?
That's a fascinating question. Article 1328 addresses exactly that. Contracts made in a state of drunkenness or under hypnosis are considered voidable.
Voidable. So not automatically invalid, but
But the person who was impaired has the option to cancel the contract later on if they choose to.
so the law acknowledges that judgment can be clouded in those situations. But it doesn't automatically assume every agreement made under the influence is bad. It gives the impaired person the power to decide.
Precisely. It's about finding that balance, protecting people from being taken advantage of, while acknowledging that not every deal made while intoxicated is necessarily unfair. Now, switching gears a bit, are there situations where a contract might be invalid, not because of the people involved, but because of what the contract is actually about?
You mean the actual content of the agreement itself?
Exactly. We already talked about how contracts can't be illegal or against public policy, but there are certain types of agreements that are simply void from the get-go because of their subject matter.
Okay, so like what? What kind of contracts would be automatically thrown out?
The most obvious category is contracts for anything illegal or criminal. Drug trafficking, smuggling, you name it. You can't just create a contract to legitimize those activities.
Right, that seems pretty straightforward. You can't use a contract to make something illegal suddenly okay.
Exactly. Another big no-no is contracts that go against good morals or customs. These are agreements that violate the basic ethical principles of society.
So like what? Give me some examples.
Think of contracts that exploit vulnerable people, contracts that promote discrimination, or contracts that involve activities considered harmful to society as a whole. Even if both sides willingly agree, these types of agreements are considered void from the start because they clash with those fundamental moral values.
So it's like there are ethical boundaries, even in the realm of contracts.
Absolutely. You can't use a contract to do something that society considers fundamentally wrong.
Okay, makes sense. Any other categories?
Another one is contracts that are impossible to fulfill. This means agreements that involve obligations that are literally or physically impossible to do.
So like a contract to deliver a unicorn or time travel?
Exactly. You can't be bound by a promise to do something that can't be done.
Fair enough. What else?
Contracts that are overly vague or uncertain are also a problem. If the terms are so unclear that you can't figure out what the parties are actually supposed to do, then it's not a valid contract.
So clarity is key. If it's too fuzzy, it's just a recipe for disagreements.
Right. Contracts need to be clear so that everyone knows what's expected of them. Now, let's talk about simulation.
Simulation. Okay, that sounds interesting. What is that and how does it affect a contract?
Simulation happens when people create a contract that looks like one thing on the surface, but actually hides a different secret agreement. It's like a legal disguise.
A contract in disguise. Sounds like a way to trick someone or get around the law.
You got it. And the law actually recognizes two types of simulation. Absolute and relative.
Okay, break it down for me. What's absolute simulation?
Absolute simulation is the most blatant form of deception. It's when the parties involved have absolutely no intention of creating a real, binding, legal agreement. It's all a facade.
So the contract is just a prop, a fake.
Exactly. And Article 1346 of the Civil Code is very clear about this. Any contract made through absolute simulation is void from the start. Poof. Gone.
Makes sense. If there was never a real intention to create a legal agreement, then there's no contract to enforce.
Right. Now, relative simulation is a bit different.
How so?
In this case, the parties do want to create a legal agreement, but they want to hide the true nature of the agreement. They might disguise a donation as a sale or use a fake price.
So it's like a partial disguise. The contract exists, but it's not what it pretends to be.
Exactly. And Article 1346 addresses this as well. It says that in cases of relative simulation, the hidden agreement is judged on its own merits. If it meets all the legal requirements for that type of agreement, it can be enforced.
So the court looks past the disguise and examines the real deal underneath.
You got it. They peel back the layers to see if there's a genuine enforceable agreement at the core.
That's pretty clever. You can't just dress up a contract to avoid legal requirements. The court will see through the charade. Now let's switch gears and talk about two crucial elements of any valid contract: object and cause.
Ah, yes. The what and the why of a contract.
Exactly. So let's start with object. What does that mean in a contract?
The object is the subject matter of the agreement. It's a thing or service that's being exchanged. It's what the parties are agreeing to do or to give.
Seems straightforward enough.
It is, but there are some things that could make the object problematic or invalid. Article 1347 gives us some guidance here.
Lay it on me.
First, the object has to be clearly defined, or at least determinable. You can't have a contract for something vague, like a good time or something valuable. It needs to be specific.
No wishy-washy promises.
Exactly. And of course, the object has to be legal. It can't be something that goes against the law or public policy.
Right, we already covered that. No contracts for illegal activities. What else?
The object also has to be something that can be legally traded or exchanged. It needs to be something within the realm of commerce.
So no contracts for selling unicorns or buying a planet.
Exactly. It has to be something that can actually be bought, sold, or exchanged legally.
Okay, now for the why, the cause of the contract. What does that refer to?
The cause is the reason why someone is entering into the agreement. It's their underlying motivation, the why behind their willingness to be bound by the contract.
So it's about understanding their intentions.
Yes, their purpose for making the deal. And Article 1350 gives us some guidelines here.
Okay, what are those?
First, the cause has to exist at the time the contract is made. It can't be based on something that might happen in the future or something that happened in the past.
So no contracts based on wishful thinking or past favors.
Right. It has to be a current concrete reason. And of course, like the object, the cause has to be legal.
No illegal motivations.
Right. And finally, the cause have to be genuine. The reason stated in the contract needs to reflect the party's real motivations.
No hiding the true purpose then.
Exactly. The cause must be real, lawful, and accurately reflect what the parties are trying to achieve. Now, this is a question I'm sure many people have. Does a contract have to be in writing to be legal?
Yeah, that's a big one. Does everything need to be signed, sealed, and delivered?
Article 1356 gives us a pretty clear answer. Contracts are generally binding no matter what form they take, as long as all the other requirements are met.
So a handshake deal can be as good as a fancy notarized document.
In many cases, yes. But there's a catch.
Oh, there's always a catch, isn't there?
Article 1356 also says that if a specific law requires a particular form for a certain type of contract, then that requirement trumps everything else.
So you can't just ignore it, even if everything else about the contract is valid.
Exactly. It's like a legal trump card. If the law says you need a certain form, you have to follow that rule.
Makes sense, especially for big deals or things like real estate.
Yeah.
You want a clear record, less room for error. What are some examples where that form requirement is absolute?
Article 1358 lays out a few situations where you absolutely need a public document, a document that's been prepared and witnessed by a notary public.
Notary public.
Official.
Very official. For example, any agreement that creates, transfers, changes, or ends real rights over immovable property, like selling or donating land, must be in this public document format.
Okay, so for real estate, skip the napkin agreement, go straight to the notary.
Exactly. You want everything documented and registered properly to avoid any issues down the road.
Smart move. What about other situations where a public document is a must-have?
Article 1358 also mentions the sale of real property or any interest in real estate governed by Articles 1403 and 1405. This reinforces the need for clear documentation in property transactions. So when it comes to land or buildings, make it official. What about contracts for giving away movable property? Like, let's say, gifting someone an expensive piece of jewelry. Any specific form requirements for that?
Article 748 covers that. If you're donating movable property worth more than 5,000 pesos, the donation needs to be in writing. It doesn't have to be a public document, but a written agreement is a must.
So while a verbal promise to give away a pricey heirloom might not hold up in court, a written agreement, even a simple one, can make it binding.
Exactly. It protects both the giver and the receiver and clarifies everyone's obligations. Now, shifting gears a bit, let's talk about situations where a contract, even if it's valid, might not be enforceable.
Hold on, if it's valid, how can it not be enforceable? That seems like a contradiction.
That's where we get into the world of unenforceable contracts. These are agreements that aren't necessarily invalid, but for some reason can't be enforced in court.
So they exist, but they lack legal teeth. What kind of situations lead to this?
Article 1403 outlines a few key categories. One is when someone makes a contract in someone else's name without having the authority to do so.
So like pretending to be someone's agent without actually having the right to represent them.
Precisely. It's like a contract based on an imposter. The law recognizes that there's no genuine consent in these situations.
Right, you can't just sign a contract using someone else's name and expect it to hold up. What else makes a contract unenforceable?
Another important category is outlined in Article 1403, the statute of frauds.
Statute of frauds. That sounds serious.
It is. It lays out certain agreements that must be in writing to be enforceable.
Why those specific types of agreements?
They're usually agreements that are considered particularly important or particularly prone to disputes. The kind of agreements where having a clear written record is crucial.
Makes sense. So what kind of agreements fall under this statute of frauds?
One example is the sale of goods worth more than 500 pesos. That needs to be in writing to be enforceable.
So no more handshake deals for big purchases.
Exactly. Get it in writing. Another important category is any agreement that can't be performed within 1 year of being made.
So long-term contracts.
Exactly. Long-term contracts for services, leases, anything where the obligations extend beyond a year. Having it all written down helps avoid disputes later on when memories might have faded or evidence might be lost.
Right, it's like a safety net, ensuring that those important long-term agreements are clear and documented. But what if a contract should be in writing, according to the statute of frauds, but it isn't? Is it automatically doomed?
Not necessarily. While a written form is generally required, there are some exceptions.
Exceptions, tell me more.
One exception is when there's been partial performance of the contract.
So if the parties have already started doing what they promised in the agreement, even without that written document.
Yes. In certain cases, those actions can be strong enough proof of the contract's existence and its terms. It can override the lack of a written agreement.
So sometimes actions do speak louder than words. It seems like the law aims to be flexible and fair, not overly rigid.
Exactly. It tries to strike a balance between following the rules and ensuring justice in real-world situations. Now, let's shift our focus to the people involved in these contracts. We've discussed how minors and those with mental impairments might not be able to fully consent. But what if someone is tricked or pressured into signing a contract?
Right, what happens if someone didn't really agree freely and knowingly?
That takes us to the realm of vitiated consent. Consent is considered vitiated when it's given under duress, mistake, fraud, undue influence, or misrepresentation.
So those are the things that can taint the consent and make it invalid.
Exactly. These situations essentially mean the consent wasn't truly free and informed, which throws a wrench into the whole contract.
It's like signing a contract under a cloud of doubt or coercion. What are some examples of how consent can be vitiated?
Let's start with mistake. Article 1331 explains what kind of mistake can actually invalidate consent. It has to be a mistake about the fundamental nature of the thing being agreed upon, or about a crucial factor that led one or both parties to enter into the agreement.
So it can't just be any old mistake, it has to be a significant one.
Right. A mistake about a minor detail won't necessarily void the entire contract. It has to be a mistake about something essential that truly affects the parties' understanding and willingness to agree in the first place. Now, what about situations involving violence or threats? Article 1335 addresses this head-on. Violence or intimidation exists when someone is forced to agree to a contract out of a real fear of harm to themselves, their loved ones, or their property.
So it's not just about physical force. It's about any threat that creates genuine fear and pressures someone into a contract against their will.
Exactly. It includes psychological coercion, threats, the whole gamut. The law recognizes that psychological pressure can be just as effective as physical force in getting someone to do something they don't want to do.
So true consent means a genuine agreement, free from that kind of fear. Now, what about undue influence? How does that fit into this whole picture of vitiated consent?
Article 1337 gives us the details on undue influence. It happens when someone abuses their power over another person, essentially taking away their ability to make a free and informed choice.
So it's about exploiting a position of power.
Exactly. Think of situations with a big power differential, like between a doctor and their patient, or a lawyer and their client, or even between family members when one person has a lot of control over the other.
That's why it's so important to have these safeguards in place.
Yeah.
People can be vulnerable to manipulation in those situations.
Absolutely. The law is designed to protect those who might be more susceptible to that kind of pressure, ensuring that their consent is truly their own. Now let's move on to another tactic that can invalidate consent. Fraud.
Fraud. That sounds pretty serious.
It is. Article 1338 describes it perfectly. It's when one party intentionally uses sneaky words or schemes to trick the other party into agreeing to a contract they would have rejected if they knew the whole truth.
So it's not just about lying. It's about actively deceiving someone to get their signature on a contract. What are some specific tactics that might be considered fraudulent?
Article 1339 gives us some clear examples. For instance, deliberately hiding crucial information, especially when there's a duty to disclose it, is a big red flag.
So it's not just about outright lies, it's about strategic omissions, keeping secrets that could influence the other person's decision.
Exactly. Sometimes staying silent when you should speak up can be just as misleading as making a false statement.
This emphasizes the importance of good faith in contract negotiations. You can't build a strong agreement on a foundation of deception. Now, let's discuss the last element that can impact consent: misrepresentation.
Misrepresentation is often confused with fraud, but there's a key difference. While both involve giving inaccurate information, misrepresentation doesn't require an intent to deceive. It can happen even when someone genuinely believes what they're saying is true.
So you can misrepresent something without meaning to.
Exactly. It's about the accuracy of the information, not necessarily about the intention behind it. And Article 1342 explains that misrepresentation from a third party, someone not directly involved in the contract, won't invalidate consent unless it leads to a major mistake that both parties share.
So if someone outside the contract throws in some wrong information, it won't automatically void the whole agreement unless both parties fall for it.
You've got it. It's not simply about the presence of false information, but about whether that misinformation actually affected the agreement of both parties.
Okay, that's a subtle but important distinction. Now let's talk money. What about this concept of lesion that's mentioned in the source material?
Lesion refers to a situation where there's a big imbalance in the value of what's being exchanged in a contract. One party might be getting a significantly better deal than the other.
So it's like one side is getting ripped off. Doesn't that go against the idea of a contract being fair to both sides?
You'd think so, right? But Article 1355 says that lesion, on its own, doesn't usually invalidate a contract.
Wait, really? So even if one party is clearly getting a worse deal?
There are exceptions, of course. Article 1355 points out that lesion can be grounds for invalidating a contract if it's coupled with other problems like fraud, mistake, or undue influence.
So it's like the lesion is a red flag that something might have gone wrong during the consent process.
Exactly. It suggests that one party might have been tricked or pressured into a bad deal.
So it's not just about the numbers, it's about the overall fairness of the agreement.
Precisely. Lesion acts as a warning sign that the court should take a closer look and make sure there was no foul play involved.
Okay, so it's another layer of protection built into the law. Now let's talk about rescindable contracts.
Rescindable contracts are agreements that are valid at the start, but due to certain circumstances can be revoked or undone.
So they're not void from the get-go, but can be reversed later on.
Exactly. Think of it like a contract with an undo button. And Article 1381 lists the grounds for rescission.
What are some of those?
One common situation is when a guardian makes a deal on behalf of a minor, and the deal ends up being very unfavorable to the minor.
So the guardian isn't acting in the best interests of the person they're supposed to be protecting.
Right. The law steps in to protect the minor's financial well-being.
That's an important safeguard. What are some other examples?
Another ground for rescission is when a contract is made specifically to defraud creditors.
So you can't use a contract to hide assets and avoid paying debts.
Exactly. The law protects creditors from that kind of scheme.
Makes sense. Any other scenarios?
Article 1381 also covers cases where a contract involves things that are already being disputed in court. If someone tries to make a side deal without the knowledge or consent of everyone involved in the lawsuit, or without a court order, that contract can be rescinded.
So you can't just make backroom deals that could interfere with an ongoing legal battle.
Right. Another ground for rescission is when a contract is used to deliberately cheat someone out of their rightful ownership of a property.
It's all about ensuring fairness, preventing people from using contracts as tools for fraud or manipulation.
Exactly. But remember, rescission is usually the last resort. Courts generally prefer to uphold contracts whenever possible.
So it's not something to be taken lightly. It's good to know those safeguards are there, but it's important to understand the seriousness of contracts and the importance of honoring agreements. Now, this next concept adds another layer of complexity. Vices of consent.
Vices of consent refer to specific flaws in the consent process that can make a contract voidable.
So we're zooming in on that consent process and identifying specific issues that could render it invalid.
Exactly. It's like using a legal microscope to examine how that consent was given and looking for any cracks in the foundation.
Intriguing. So what are some of these vices we should be aware of?
One of the key vices of consent is error or mistake.
We talked about mistakes earlier, but are there different types of mistakes that are considered vices?
Yes. Article 1331 outlines several categories. One is mistake of fact, which happens when one or both parties are wrong about a fact that's essential to the contract.
Like agreeing to buy a car thinking it's a 2023 model when it's actually a 2013.
Exactly. That kind of mistake about something central to the agreement can be grounds for voiding the contract.
Makes sense. It wouldn't be fair if every little factual error could undo a contract. What about mistakes about the law itself? Can those be considered vices of consent?
That's where things get interesting. Article 1334 says that in most cases, a mistake of law doesn't invalidate consent.
Really? So even if someone claims they didn't understand the legal jargon?
Well, ignorance of the law isn't an excuse for breaking it. But there's a nuance here. Article 1334 also says that if the law in question is particularly complex or ambiguous, a mistake about that specific law could be a reason to void the contract.
So if the law itself is murky, a mistake about that particular law might be a valid defense.
Exactly. It protects people from being unfairly.
Yeah.
Exactly. It protects people from being unfairly penalized when the rules themselves aren't clear. Now, let's revisit the concept of violence, or duress, as a vice of consent.
We discussed violence and intimidation earlier, but is duress something different?
They're often used interchangeably, but duress usually refers to any kind of unlawful pressure or force that compels someone to agree to something they don't want to do. It can be physical or psychological.
So it's a broader term that encompasses a wider range of coercive tactics. What are the essential elements of duress that would make a contract voidable?
Article 1335 breaks it down. First, there has to be a threat that forces the person to consent. Second, that threat has to be unlawful or unjustified. And third, the threat must create a genuine fear of serious harm.
So it's not just any fear or pressure. It has to be a legitimate fear stemming from an actual threat.
Exactly. It's about protecting people from genuine coercion, but also ensuring that contracts aren't easily broken just because someone felt a bit pressured. It's a balancing act. Now, how about undue influence? We touched on this before, but how does it act as a vice of consent?
Refresh my memory.
Undue influence happens when someone abuses a position of power or trust to manipulate someone into an agreement they wouldn't freely make. Article 1337 dives deeper into this, stating that it's about taking unfair advantage of that power, essentially overriding the other person's ability to make a genuine decision.
So it's about using a relationship to pressure someone into something they don't want. Are there certain relationships where this is more likely to happen?
You see it often in situations where there's a clear imbalance of power, a doctor and their patient, a lawyer and their client, even family members, where one person has significant control over the other.
It's good that the law recognizes these dynamics and offers protection. Now, let's go back to fraud as a vice of consent. We talked about it before in the context of vitiated consent, but what makes it a vice?
When we talk about fraud as a vice of consent, We're zeroing in on deliberate acts of deception. Remember Article 1338, it says fraud involves using tricky words or schemes to mislead the other party into an agreement they would have rejected if they knew the truth.
It's about intentionally creating a false impression to secure consent. What are some examples of fraudulent tactics that could invalidate a contract?
Article 1339 gives us a few examples. For instance, if someone intentionally hides information that they're obligated to disclose, that's considered fraudulent, especially if there's a relationship of trust involved.
It's not always about telling blatant lies. It can also be about strategically concealing information.
Precisely. Silence can be just as deceptive as a lie when you have a duty to speak up.
This underscores the importance of honesty and transparency in contracts, no hiding crucial information.
Now, let's wrap up with our final vice of consent misrepresentation.
We touched on this before, but what distinguishes it from fraud as a vice of consent?
The key difference is intent. Fraud requires a deliberate intention to deceive, while misrepresentation can happen even if someone genuinely believes what they're saying.
So you can misrepresent something without meaning to mislead the other person.
Exactly. It's about whether the information was accurate, not about whether the person intended to mislead. Article 1342 reinforces this, stating that misrepresentation by a third party, someone outside the contract, won't invalidate consent unless it caused both parties to make a big mistake.
So it hinges on the impact of the misinformation, not just its presence. Okay, I think I've got a pretty good grasp on these vices of consent now. It's amazing how much nuance there is in something that seems so simple, agreeing to something.
Contracts are full of subtleties, and it's these nuances that can make or break a deal.
Well, this has been a whirlwind tour through the world of Philippine contract law. We've covered so much ground from defining a contract to exploring those tricky vices of consent. We even delved into real-life cases like Sisuan versus Regala and Kokia versus Fieldman's Insurance Co., which brought those legal principles to life.
It's always fascinating to see how these concepts play out in real-world scenarios.
It definitely shows you how important it is to understand the rules of the game before you enter into any agreement. But, as always, we're left with some food for thought. Our source material mentions a concept called natural obligations.
Ah, yes, those are interesting.
They're not legally enforceable, but they're considered morally binding. It makes you wonder, could these natural obligations ever influence a court's decision in a contract dispute?
Now, that is a question worth pondering.
It is. It just goes to show that law isn't just about black and white rules. It's also about navigating those gray areas where morality and legality intersect. Thanks for joining us on this deep dive into the fascinating world of obligations and contracts in the Philippines.